Balake. Where's Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Aaron.
Aaron is a present. Welcome back for more SPTV, everyone, where every day is a great day not to be in a cult. We're talking today about Danny Masterson's sentence. And I've spoken about this before on my channel, but this conversation needs a bit of an update. So I'm joined today by, drumroll please, my attorney friend, Zach Morgan.
Hey, everybody.
How is it going, man? It's been a while.
It's good. I'll apologize to your viewers ahead of time, and I think even the few viewers on my channel were having some audio issues. That's not Aaron's fault. I had to added some equipment, and I've got an issue in the workflow. So I know it's not great. Bear with us. We'll get through it. I promise.
Yeah, I think it's serviceable. And for those who may not yet be familiar, Zach's channel on YouTube is Your Lawyer Friend Zach. And yeah, got to check that out. Highly recommended. Okay, so the reason I wanted to have a conversation about this is because ever since the beginning of the Danny Masterson trial, whenever I've spoken about how many years in prison he was facing, it was 15 years to life for each one of the charges that he was facing. He was found guilty of 2 charges, so therefore 30 years to life. And as a layman, as someone who doesn't understand all the intricacies of the laws and sentencing and all this stuff, I had been under the impression that we were essentially waiting for the judge to decide that what specifically Danny's sentence was going to be, and that the minimum she could give him was 30 years, but that she might come back and say 40, 50, 60 to life. And a few weeks ago, I was contacted by somebody related to the case who wanted to explain to me that's not actually what 30 years to life means, and that his sentence is in fact 30 years to life. And it was explained to me that what this means is he is not eligible for parole until 30 years. And
Okay.
And that due to the nature of the crime, the rules about serving 80% of your sentence or 85% of your sentence and then being eligible for parole do not in fact apply to him. And that what we're actually not waiting, because the sentencing hearing is scheduled at this point for September 7th, if I recall correctly. So we're not waiting. But I'm sorry, I'm going to be a little scattered in my thoughts here, but I'm going to try to bring it all together.
It's all right. We'll keep up with you. I promise.
And because I had this idea that it's a mandatory minimum sentence is 30 years, I was wondering, what is the point of the hearing? What is it that the defense team is even going to be arguing for? What is it that the prosecutor is even going to be arguing about? And it was explained to me that in Danny's case, there's something called the aggravating circumstance here having to do with the use of a firearm in the commission of one of these crimes. And, you know, in Danny Masterson's attack on Jane Doe 1, he brandished a firearm at one point during the process of the attack. The aggravating circumstance, and I'm just sharing what's been, told to me.
Sure.
The aggravating circumstance, it's up to the judge to decide whether she essentially is going to admit that as a fact. Like, the jury was not asked to make any ruling whatsoever on whether a firearm was used in the commission of the crime. We heard a lot of testimony about it. That issue was never put to the jury. They were never required to make a decision on that. And yet the judge is allowed to make a decision on that. And that if she decides to throw out the issue of whether a firearm was used, then his sentence, he will be eligible for parole after 30 years and not sooner. And that if the judge rules that, yes, she does believe the firearm should be an aggravating circumstance, and she rules that, yes, I basically accept it, that his sentence is life. And this is where my understanding of this gets a little fuzzy, or I start mentally running into, contradictions, because how often have we heard of people convicted of murder getting out of prison after a certain number of years? And I just find it hard to believe, and it's possible that I've been misunderstanding even still what's been explained to me. I find it impossible to believe that the crime that Danny's been convicted of, even with an aggravating circumstance of a firearm would give him a stronger sentence, like life in prison without the possibility of parole, would give him a stronger sentence than someone who had been convicted of, say, capital murder. So I'm hoping that you can help me understand what the hell's going on here.
Sure. So it's a little bit messy. So I'm going to take what you said, and we'll break it down to a variety of components and sort of take them one at a time. The first is the sentence. A lot of people think, as you mentioned, well, 30 to life, that's 30, but then he misbehaved and really made the judge mad, so now it's 40, and 40 becomes 50. No, the sentence, the judge will sentence him to a period of incarceration, a minimum of 30 years, maximum of life. And then she will say 30 years to life imprisonment in the California Department of Corrections, or whatever they call it out there. That is a true statement. The 30 years is also a fixed mandatory minimum. It will not be less than 30 years. Upon reaching 30 years, Danny will have the right to petition the California Pardon and Parole Board or Commissioner, whatever they call it, for the ability to be paroled. They don't automatically necessarily have to grant it. In fact, one of Charles Manson's followers just got out after over 50 years, and she was up for parole consideration probably 30 times. So it's up to the Pardon and Parole Board, and then theoretically goes to the governor for final consideration in most states. So it's a minimum of 30 years. The judge will enter a finding of fact, what's called a finding of fact and conclusions of law. The finding of fact is, here's what I, as the judge, determine the facts to be, because California juries do not sentence. It's handled state by state. In some states, jury sentence. In some states, the judge sentences. In Texas, for example, the defendant, if convicted, gets the choice. Do I want the judge to sentence me, or do I want the jury to sentence me? In some states that have the death penalty, which California does not. In state, I don't think they might. In the states that have the death penalty, in some states that have death penalty anyway, the jury or the judge at the discretion of the defendant. It sort of varies state by state, but we know this: it'll not be less than 30 years. Then there's the aggravating factor. What the judge will do is the judge will review the pre-sentencing report, which I think is something, a part of that we need to talk about, and Danny's refusal to participate in certain parts of the pre-sentence investigation, which is super routine. Every jurisdiction does that. Every jurisdiction has a pre-sentencing system. So pretty simple. And then there's also any number of factors. I've got sort of a list of them here. But the judge can take those factors and give as much or as little weight. And the judge reaches that based on the testimony she heard at trial, based on what the jury found in its jury forms that it returned with a guilty verdict, based on the testimony that the judge is going to hear at the sentencing hearing. The victims will have the right to speak. Victims' families have the right to speak. The defendant will have the right to speak. The defendant's family will have the right to speak. Everybody has the right to address the court and beg for either a harsh sentence or leniency. And that, we see that on YouTube all the time. And a dad freaks out because his daughter was murdered or something along those lines in the sentencing hearings. And so, I see here a list of about 8 or 10 factors. The gun is one that, if the judge determines as a matter of law that a gun was present, it automatically elevates the crime. I don't know enough about California law to say conclusively, if you have a gun in the commission of a felony, it automatically becomes life without parole. That doesn't seem to match most sentencing policies around the country, but it would elevate it from a base of 30 to some other higher minimum. Instead of getting to 30 years to qualify for parole consideration, it'll elevate it to another level. 40, 50, however many years. But it's things like, was the defendant armed, or did the defendant use a weapon? What is the vulnerability of the victim? Certainly the vulnerabilities of the victims are key here, because of the allegations of drugging and chemically altering drinks to create a stage of either incapacitation or incoherence. Whether you inflicted physical or emotional injury upon the victim, right? Without getting into the details, because this is a YouTube stream, if those who follow the testimony know what some of the allegations were and what the jury's findings were. Whether the defendant was an active or passive participant. Well, he was the only illegal participant, and it was certainly an active role. Whether the manner in which the crime was carried out demonstrated criminal sophistication or professionalism. Okay, this wasn't a crime of convenience. It wasn't a purse nabbing because a lady walked by with her purse open, right? There was planning, there was coordination, there was timing. You know, he had the drinks prepared, he had the chemicals ready, whatever it was. Okay, so Nasty Nathaniel, you know, if I take him at his word, I have no reason to doubt him. If you use the firearm commission automatic 5-year enhancement, that takes from a minimum of 30, minimum of 35 now. And then a couple other ones, or the last one, whether you took advantage of position or trust or confidence to commit the crime.
Yikes.
Yeah.
Wow.
So I do see over here suppressive pup love. Why is drugging not considered an aggravating factor? And I think it is. I think we just talked about that. Whether the manner in which the crime was carried out demonstrated criminal sophistication or professionalism, and whether you took your advantage of a position of trust or confidence. These victims were guests of Danny Masterson in his home. There were more than just these two victims, of course, but the two victims for whom convictions were secured, not the other Jane Does. The two victims for whom convictions were secured were guests in Danny Masterson's home. They were certainly out of their element. It's kind of like me going to your house. I'm a visitor at your house, and so I'm sort of subject to the rules, and what happens in your house is sort of the rules I have to play by. And so certainly some considerations there as well. Amazing. So I think that's sort of part one, or part 1A of the inquiry.
And so I guess this is where, and it's one of the reasons I wanted to continue this conversation with you, because, well, every time we discuss this publicly on the channel, someone will reach out and in a helpful manner attempt to correct the record or provide additional data. It's just that people who do that all tend to provide some slight different version of what they think the truth is. And unless I were to sit down with Deputy DA Reinhold Mueller himself, it's hard to know whether we've gotten to the actual truth of the matter. Because again, even with what Nasty Nate said here about, a 5-year enhancement, that still conflicts with the information I was given by someone close to the case that 30 years is the sentence is 30 years to life, and the enhancement has to do with whether it's going to be life. If it feels like that's probably not the truth. It feels like it's probably not either 30 or life. That doesn't.
No, it's a sliding scale. It's a minimum of 30. Well, in this case, if according to Nasty Nate, if we take him in his word, it's 35 to life. If the judge determines a gun was used, a weapon was used in the commission of this felony, 5-year enhancement becomes 35. So at 35 years, he can ask the Pardon and Parole Board, hey, I want you to consider me for parole.
So then my next question is this. In a situation where there is at least a mandatory minimum sentencing, what is it that the defense team is? Because I was led to believe that the defense team is at least going to show up and make an argument for why he should get less than 30, even if the judge isn't even allowed to give less than 30. Would they really engage in something that's just pure theater?
Yes, because the Pardon and Parole Board, at the end of that 30 or 35 years, whatever number the judge ultimately decides the minimum to be, given all the enhancements and aggravating factors, you pile all that on. Whatever number that is, the Pardon and Parole Board, at some point when Masterson applies for parole consideration, we call it the Pardon and Parole Board. I don't believe he's ever going to petition for pardon, which is the legal dismissal and going away of all the convictions. It's more part, I just want to get out and not be in jail anymore. The Pardon and Parole Board will often consider, at the request of the defendant, now the convicted person, transcripts. And so they can go back and read the arguments of counsel that his attorneys are going to make to the judge.
I see.
Just like they can also read any letters that were submitted to the judge. If somebody writes a letter because they either can't or don't want to show up in person, they can write a letter to the judge, and the judge will put that in the court file. It doesn't mean the judge will read it to the courtroom, but it means the judge will take it into consideration.
I get it. And you might have just touched on the answer to the next question I was going to ask, which is, I've sort of had the impression that the victim's impact statements and whatever the heck you call the statements that Danny's people will make. Because I believe they're going to get a chance to make some, his family members and friends will be like, oh, he's a really great guy, that kind of stuff.
Yeah.
That these statements could somehow impact the sentencing themselves. And yet I tend to think the judge would have already walked into that courtroom ready to give a sentence and isn't just making it up on the bench. What's your thoughts on that?
So in my experience, the judge is going to have a baseline idea of, if I hear no testimony, if I walk in and say, are we ready? They say yes. Does anybody have anything to say? No. Okay, I'm ready to impose sentence. But then, so I have a baseline of what I'm going to do. So then we have people come and they give statements, they make arguments, they present, their position to the court, and the court will use, if we start here, the court's going to say, okay, that's going to add some time, and I believe that's going to take some time off, that's going to add some time, and then at the end we're going to sort of have this value, and it's arbitrary. A judge doesn't have to have an articulated reason for why they impose the sentence they do. That's the discretion given by our justice system to the judge. The judge is the impartial adjudicator. They are their job is the gatekeepers to make sure the rules of procedure are filed and that everybody's rights are protected. And in order to do that, they're allowed to receive any information that they want. And then just like the jury weighs it, they weigh it. Yeah, he says this, but I don't really believe it. This person says this, but I don't really believe her either. I believe this person. I don't believe that. They're allowed to weigh that based on things like the affect. Are they giving me the right psychological manifestations of their feelings? If I'm up here ranting and raving about how horrible a person he is, but I'm giggling like somebody told me a dirty joke in church, it's sort of my affect doesn't necessarily match the emotion I'm trying to convey. So the judge is certainly going to weigh all of those factors. Now, so you just threw a statement up there that's true as well. The family and his attorneys are going to advocate for mitigating circumstances. Now, as I understand the law, it's a baseline of 30. She can't go less than 30. But if the aggravating factor of a weapon adds 5, they're going to go out and they're going to take their opportunity and try to make that 35, 33, then 32, then 31, and try to get back to 30.
Right.
Don't know how successful they're going to be, but that is his right under the Constitution. And for all those, I hear all the time, not just in this realm, but just even as a lawyer, I hear people all the time when they find out I'm a lawyer. Well, how come defendants get to stand up and try to get the judge to take it easy to them? What's their constitutional right? Right. And it's sort of like the First Amendment stuff. I sometimes have to put up with stuff that I don't agree with or believe in because it lets me say what I want to say and believe what I want to believe and promote what I want to promote. As long as it's protected, as long as it's within the limits of the First Amendment, it's the same sort of theory.
Okay, so I'm glad you mentioned this because I've wondered about that myself. When we see someone who's convicted of horrible crimes stand up right before his sentencing and make, in some cases is a very heartfelt apology, it seems sincere, it seems remorseful. It's not necessarily that anything he's saying has any effect on the sentence the judge is, minutes away from reading. It's that it may come up when he becomes eligible for parole, whether this guy from the very beginning seemed to accept responsibility for what they did.
Right. And even in extreme cases where maybe it's a death penalty case and the judge and or jury has sentenced this individual to death, they're going to make a statement because at some point they're going to petition to have their sentence commuted from death to life without parole. Not the circumstances here, but in an extreme case, they're sentenced to death, but at some point their governor and their pardon and parole board in whatever state they're in will consider their application to commute it to life without parole, and they're building a record. What I did was horrible. I was a drug addict and I was, making terrible life choices, but and then you couple that with they got in rehab and in prison and they went through all the programs and they became a model inmate and they were in charge of some sort of, small group or something. You put all those together. Okay. Yeah, you did reform your life. You did change. We're not going to let you out, but we're going to take you out of the death chamber. So that's what they're doing. They're building the record for some of this kind of stuff.
That makes sense. The other thing that's come up as a hot topic is victims' impact statements from victims for whom Danny Masterson was not charged of a crime. Have you ever heard of this happening before?
Not in the states in which I practice, but I have seen some case law on it. The case law is not, I haven't seen anything at the federal level. It's all sort of state by state. Some states allow it, some states don't. That's the beauty of our 3 or 4 tiered system of governance. starting with the federal law and then working its way down to local and community municipal law. They're allowed to sort of govern how they see fit. And in some states, it is allowed that you were not convicted of doing bad things to me, but I'm making a claim that you did this bad thing to me, and you did it 3 years before you met Jane Doe. I've never met Jane Doe. I've never seen her till I showed up here today to make that statement. I was just watching this trial through the news media or whatever. And so the judge can use that to say, hey, you were only convicted of wrongdoing against 2 people, but I either think the jury missed it with the 3rd one, or I believe all of these other women. This is a pattern of behavior where we see a similar mode, we see a similar method and manner, we see a similar victimology, and these victims don't know each other, or they didn't know each other prior to them coming together in this space for this event.
Right. You know, what's amazing is that at the last hearing regarding the sentencing, when the prosecutor said he wanted all of the victims who had testified in the case to be able to make victims impact statements, the judge was 100% on board and did not shut it down. She tossed it over to the defense team and said, do you have any objection? And he was like, basically, yeah, of course we have an objection. But what was amazing to me is that the judge herself didn't shut it down. And yet everyone who's contacted me on this issue says it is unheard of for victims who were not charged. Because there's victims who want to speak who weren't even charged. Like, for those who may not know, there were Danny Masterson victims who were allowed to testify in this case as prior bad act witnesses, even though Danny was not charged with crimes against those women. And so at least to a certain extent, the court has, correct me if you think my language on this is wrong, the court has already acknowledged that these victims exist. Otherwise, even allowing someone to testify that said, yes, Danny did this to me as well, isn't that sort of the court saying we at least believe this was possible?
Yeah. So the whole purpose of the judge and jury system, the reason the judge sort of sits as the gatekeeper to the jury, is that the jury doesn't know the law. The jury isn't trained on the law. The jury isn't trained in how to weigh evidence. So I saw a chat over here in the chat earlier that said, well, I don't like that anybody can stand up there and tell a lie. Okay, that's true. I'll grant that. However, his guilt is already established. None of this is being used to determine whether he did or did not commit a crime. The jury has already determined, as a matter of law, a crime was committed twice.
Right. By the way, Zach, now that you've have joined the stream from the back end through StreamYard, if you see a comment that you want to address, take your cursor and put it over that comment, and you can either bring it up on screen or you can hit that little star button and it'll put it in the saved column.
Oh, okay, perfect.
Just so you know. By the way, if you're one of the 2,100 people watching live, do us a big favor and hit that like button. It's fast, it's free, it's easy, and it actually seems to help with notifications, believe it or not, which YouTube is horrible at sending out. Okay, there was another question. And by the way, in the live chat, if you guys have some questions you want Zach to tackle, go ahead and throw it in there. We're doing our best to catch questions. Do us a favor, write question in all caps before your question. It'll help us catch those. Okay. It was mentioned to me by someone close to this case that there is a possibility that the state, the DA's office, can go after Danny Masterson to reimburse the state for the cost of prosecuting him. Have you heard of this before?
Oh, yeah. See, Danny Masterson's also going to have to pay money for every day he sat in jail.
Really?
Yeah. If I sit in Oklahoma, if I sit in jail for, or at least in the big counties that I practice most often, if I sit in jail, for example, for one night, I get picked up for a DUI and I just have to sit in the tank until I sober up, and then I make my $500 bond, I'm going to be billed $53 a day to sit in jail in Oklahoma.
Wow.
Yeah. The taxpayers are sort of paying that. And so I could pay all of my fines and my fees and my penalties and everything that I have to pay for my case, but I could still go to jail for failure to pay my jail rent. They could pick me back up for failure to pay what I call jail rent. Yeah, that's super common. The cost of prosecution is initially borne by the taxpayer, and the judge doesn't have to grant the state's request. The judge will do an inquiry to determine, and this is done as part of the pre-sentence report, what is the financial status of the defendant? Is this a homeless guy who keeps getting picked up for being drunk in public? Hitting him with a cost of prosecution is only going to harm that individual because they're never going to pay it. They're just going to be going back to jail all the time for non-payment. But if you look at somebody who has a solid financial underpinning, a solid a solid bank account, they've got assets that they can sell and turn to cash, the prosecution will absolutely, we call that the taxing of costs. They will tax those costs to the defendant and say, hey, you have to pay for this.
Very interesting.
It's not a guaranteed thing, but it's handled on a case-by-case basis based on the financial resources of the defendant.
There's another issue that somebody pointed out to me, which is that if Danny Masterson ever does get out on parole, 35, 40, 50 years or whatever, I mean, he won't be alive in 50 years, but he would almost certainly be on one of those registries for people who have convicted offenses of a sexual nature, right?
Mm-hmm.
And I was told that, at least in the state of California, people on that list are not allowed to go to churches. Are you familiar with this?
Yeah. That is one of those events, or that is one of those cases where that's one of those facilities that offenders of that type cannot go to.
Because that means Danny would never be allowed to do Scientology in an org, even if he were to get out. I just wish this guy would take advantage of this period to just tell all of what Scientology did to silence these victims, help the victims in the civil trial. And if he were to help the victims in the civil trial, could that be something that might be taken into consideration when he comes up for parole eventually?
Yeah, it absolutely would. The time to do that is honestly, the time to do that is before trial. Of course, that doesn't happen. I saw a comment earlier and it said, well, could Danny catch a plea bargain with the state? No, the jury's already back. Danny had until the moment the judge read the verdict into the record to reach a plea agreement. Right. Once that verdict is read, nothing he can do. At that point, he is now a ward of the state of California.
So he can't strike a plea deal, but is it fair to say that literally anything that happens between now and whenever he comes up for parole, hopefully in sometime later than 30 years, anything he does that could show he has made some sort of change, showed some sort of remorse, taken some sort of responsibility is something the parole board will take into consideration?
In fact, that's often a baseline standard for the parole board to even take your application seriously. Right? Have you, if you were a drug addict, did you go through rehab? If you were an alcoholic, did you go through rehab and get clean while you were in prison? Did you, join some sort of men's support group, or did you, get a job and you were the manager of the kitchen floor scrubbing crew, whatever it was? Did you do something to improve your life in whatever way that was? Did you sit down and meet with the victims? Did you meet with the police and say, here's everything I did wrong? Or here's everything that I know this organization did wrong, or I believe this organization did wrong. Here's a list of people who helped me cover all this up. So those don't help them now. With the civil trials pending, and I got a note to talk about a different civil trial in a few minutes, but with the civil trial pending, he can no longer assert the Fifth Amendment privilege as it pertains to the two Jane Does he's been convicted of. Or the crimes against the two Jane Does for which he's been convicted, rather. Let me put the words in the right order. He cannot assert the Fifth Amendment privilege as to those two ladies anymore.
Very interesting.
We talked about this earlier, but the Fifth Amendment it's not a moving target, but even if he was found not guilty, he couldn't take the Fifth. And if he's already been convicted, he can't take the Fifth. The Fifth stops you from getting convicted. If you've already been convicted, you have nothing to protect yourself against.
Right. Okay, so let's tackle a couple questions. I have a hard stop in 20 minutes.
Perfect.
Let's see here. Okay, so this says, Will Gunn, the state charges the freeloader debt up front. I like it. Okay, Mike W says, question, is it true that Scientologists believe in immortality? If so, doesn't it make his jail sentence super easy to do? Why the crying from family? Does that show they don't really believe? Mike, the belief in the immortality has to do with you as a spiritual being. It doesn't have to do with your body. And, Scientologists enjoy their physical freedom just as much as anyone else. So,
even if we were to grant the assumption that's true, prison time still sucks. It doesn't matter whether you have immortality or not. Prison is not a pleasant experience.
Yeah. Trevanon asks, can Danny Masterson get auditing while in jail? Can an auditor visit him? I can only answer this from the Scientology side, but Zach, I'd be curious to get your answer from the, the prison side. Theoretically, I mean, even Charles Manson received Scientology auditing while in prison. Now, granted, it wasn't from someone who was visiting him on behalf of Scientology. It was just from the fact that there happened to be someone in the prison who was a trained Scientology auditor and was auditing people in the prison just on, lower level introductory type auditing processes. So I'm going to guess Scientology ain't sending anybody to go audit Danny Masterson, but
that's the deal.
But let's say they were going to, right?
Yeah.
Would they auditing someone requires being in a private space. You can record the space, they can be looking in, but it would require the ability to have physical contact, be in close proximity to, and potentially have physical contact with. Would anything like that be permitted in a prison setting?
No. So he has the right to practice his religion however he sees fit. However, he cannot. And the prison will have a chaplain, and that chaplain is going to be versed in most of the major religions. They'll be able to talk about Jewish faith to Jews and to Christianity to Christians. Probably isn't going to have a whole lot of training on Scientology. So if the church, if the organization chose to send somebody into Danny to allow him to practice Scientology, they have the right to do that. They also have the right to bill Danny for those charges. They're not sending anybody in there.
No, they're not. They are not. Nor do I think Danny would actually want it. I mean, Danny's never done much of the Bridge to Total Freedom, even when he had the freedom to do so. So yeah, that's interesting question though. Okay, Joni Cummings, thanks for bringing the information to light and explaining all of it. My question is, can the Jane Does go after Danny? Individual lawsuit. Can David Miscavige and Scientology be held responsible as well? I have to make sure I understand this question. Here's the way I'll answer the first half of this question. To the best of my knowledge, we should not expect to see some sort of a civil lawsuit against Danny Masterson from the Jane Does relating to the attacks themselves. I don't even think that's on the table. I don't think anyone's looking at that. And I don't honestly know what the difference is between this situation and, for example, the O.J. Simpson situation where, the victim's family went after him on a civil case. And I honestly don't even want to discuss the difference.
There's no difference.
Okay. All I know is we haven't heard anything about that. I don't think David Miscavige or Scientology can be held responsible at this point for anything that Danny Masterson did to these women, except for the obstruction of justice, for which there still is a grand jury investigation convened on that. And I think we will see David Miscavige and Scientology dinged on that. That's my hope, at least. Anything else you want to add on this?
You got it.
Okay. Okay. Autism Mom 07. What about Nassar's case, in which 100 plus victim impact statements? Yes, that is the example most people use when in this conversation. Was there something, were some extenuating circumstances there why that was allowed?
No, there were. He was convicted of SA of over 100 victims. So you're going to have at least 100 victim impact statements. Each victim has the right to speak. So it was a crime. It was just a very large scale crime that happened over 30 years. You had over 100 victims, over 100 people spoke. It's just a math equation there.
Okay. Cassandra Reiners, I don't have a question. I just want Aaron to say button. I love when you say that. I wonder if you're talking about the fact that I say button instead of button. Anyway, there you go. I hope you enjoyed that, Cassandra. Rob Odom, will he have to admit to the 2 sexual assaults that he was convicted of, or can he deny it under oath?
If he denies it under oath, the jury will be given an instruction. First, that answer will be stricken. The jury will be instructed that he did, in fact, commit SA and the R word against these 2 women. That is a fact that has been decided by a court. He cannot deny it.
There's not going to be a jury at this. There's not going to be a jury, though.
Not during the discovery phase, but at trial on the civil case there will be. Not during a deposition, but during the actual trial phase.
Oh, Okay, I was assuming that this statement had to do with the victim's impact statement hearing, but you think this might be referring to the civil case?
If he's referring to the civil case, he can't deny it. He can stand in front of the judge on the criminal case and say whatever he wants to. The jury's already decided that fact. That's simple.
That makes sense. Courtney Shaw, why do some juries decide and some judges decide?
It's handled on a state-by-state basis. It depends on how the state constitutions read and how their various criminal justice systems are set up. There's no rhyme or reason. It's as arbitrary as it sounds.
Okay, Free Xenu Project. Would Danny Masterson be put in general population?
You've had some experts on there. I would refer them back to some of those videos that you've had with some experts regarding that. Not initially. He might at some point, but initially he's going to be in what California refers to as a sensitive needs yard. Because of the nature of his crime, it's not to protect other people, it's to protect him from other people. He's committed a crime that's one of those unforgivable curses if you follow the pop culture meme there.
Sydney Moe asks, question, would Scientology orgs even be considered churches by the court? Very good question, and the answer is yes.
The Scientology is considered a religion, and so is the Church of the Flying Spaghetti Monster, which is also a recognized religion by most courts.
Amazing. Okay. Joel asks, does anyone think Danny was the only Scientologist doing this? Nope. Nope. We know very, very well that a great number of Scientologists have done things similar to this, including doing things similar to this against children. And in almost every single one of those cases, Scientology has proactively taken steps to silence the victims, threaten the victims and their families with consequences if they would go to the authorities. And it's one of the things I take great pleasure in highlighting on this channel is the people whose crimes Scientology have helped cover up. And people have sent me so much more information that I haven't even gotten to yet, but I most certainly will. By the way, anyone who emails me about things like this, believe me, I get your emails even if I don't respond to them. So, any of you out there in Scientology land or former Scientology land who knows of a child, someone who has committed crimes against children that Scientology knew about and covered up, please email me at growingupinscientology@gmail.com, and I will eventually cover it in a video. That is for sure. All right, let's see. I know that I saw some others that I had starred. Give me just one sec. Here's an interesting one. Lauren Quigley, does the United States on any level have traveling judges in an effort to keep sentencing for the same crimes in different local areas?
No, the sentencing is set forth by statute, and it is intentionally up to the judge to interpret the sentence and apply it to the facts of the case.
There you go. Cindy Moe, if the firearm was illegal, would that worsen the mitigating circumstances?
Nope, it would have been a different charge. He was not tried on the charge of an illegal or unlicensed weapon, so that doesn't matter.
Okay. Nasty Nathaniel asks, Aaron, if you see this, can you ask Zach if Danny Masterson could possibly be released on an appellate bond pending the outcome of his appeals?
Not based on the nature of his crimes. I've never actually seen that happen in state court. It happens in federal court fairly often. Well, not waiting on the appeal. You'll still go to prison, but you can get like a delayed entry, and we see it with Holmes and Theranos and whatever. But I've never seen it at the state level, so no.
Okay, Vanessa, the priestess of petty. I love it. Question: could his sentence be lowered if he becomes a cooperating witness against Scientology in a future case?
He had to get that done before the conviction. He's out of time. He made his choice.
So his sentence couldn't be lowered, but based on what we've discussed, is it possible that cooperating in such a way might come into play, might impact his likelihood of being paroled when he finally becomes eligible?
Yeah, absolutely. In fact, part of the agreement, it's always in writing. These agreements are contracts. Is hey, if you testify and do everything we need you to do, we will write a letter. We, the government of California, will write a letter on your behalf asking that they let you out early.
Right. Okay, Peter Anderson, question, Aaron, how much closer are you to writing that check to the Aftermath Foundation? So guys, when I hit 170,000 subscribers, I've pledged $500 donation to the Aftermath Foundation. I'm less than 900 subscribers away. So many of you viewers out there have pledged to either match or partially match that donation when I cross that threshold. So hopefully it'll be this week, guys. I think we might even be able to raise as much as $10,000 for the Aftermath Foundation. So, but whether it's today, next week, or next month, that's the goal. All right, let's see. I think I saw another super chat come in. Carrie, is it illegal to have a loved one taken away? Wait, is it illegal to have a loved one taken away from a cult for deprogramming like they used to do many years ago? My understanding is yes. It's one of the reasons you don't hear much about deprogramming these days is some of the methods used did break the law. Sometimes technically it was kidnapping. And this is one of those things I have to check myself on actually every now and then, because in Scientology, there's certain things that we were fed so much propaganda on that sometimes I have to ask myself whether the feelings I have in present time are still a carryover from the propaganda we were fed in Scientology. And that has to do with the idea of psychotropic drugs, counseling. And honestly, this deprogramming thing is something that you'd be surprised how much deprogramming was discussed in Scientology, and that it was basically this, psychiatric conspiracy to kidnap and recondition Scientologists. And to me, deprogramming is a very, very dirty word. And I don't know if other people see it as a dirty word or not, or if that's just because of how it was discussed in Scientology.
The way the military refers to that, they now call that repatriation.
Huh.
It accomplishes the same goal. It's the intense therapy, the intense counseling, the intense the rebuilding your support structure, identifying that what happened to you was not okay, identifying that what happened to you was illegal. They do it in a much more psychologically sound way now. But the military often refers to that as repatriation. If you have somebody who's been kidnapped or captured in combat, or they're rescuing American hostages or something, the term they use is repatriation.
Yeah. I guess the last thing I'll say on that subject is I certainly am willing to go on the record and saying I would never support an effort to take someone against their will away from where they are or with the people that they are, just for the purpose of doing what you think is best for that person. And that even includes leaving a cult. But again, I just speak for myself. And when people contact the Aftermath Foundation and want our help convincing someone to leave Scientology, and again, I guess I'll just speak for myself here. Whenever that question has been posed to me, I've said, nope, we are not in the business of changing someone's mind. When someone wants to leave Scientology, we will move heaven and earth to help them, but we will not try to convince people to leave. We are not in the business of twisting people's arms or, you get the distinction that I'm making.
The only caveat I would put on that would be, there are times with a valid court order in which a judge has made a determination as a matter of law that a person is in an unsafe location or something unsafe or dangerous is being done to them, or they're part of something dangerous or unsafe, in which a court order can force the removal of that person against their will from that environment. But that's because the reason I support that is because there is an independent third party, a judge, looking at the case, looking at the facts of the case in an impartial perspective, without the emotions of the family, without the attitudes of the lawyers, and trying to determine what is in this person's best interest legally. In that case, I'm okay with it because there's a court order. You have the support of law enforcement. You're doing things within the confines of the law.
There you go. And I want to comment on this. There was one particular instance that comes to mind where a group of friends found out that someone who had been in their friend group for decades was secretly a Scientologist and had never told them. And they just found out that she was planning on selling her business, selling her house, moving to Flag, giving them all their money. And they said, look, we are basically going to stage an intervention. And I said, well, if you're going to do that, I will give you tips on how to make it hopefully have the best chance of succeeding. And I said, but if you're going to do that, I want you to understand you should only do it if you're prepared for her to never speak to you again. And if you feel like if that's your call, but I would never, that's an example where I would never have tried to convince this woman's friends to stage an intervention. But I said, but if you're telling me you're going to do this no matter what, I'm happy to advise you with some tips. And believe it or not, they succeeded. They got their friend out of Scientology. It was unbelievable. Unbelievable. Very last question here. CinemaFan97. Can the judge give concurrent sentences for Danny's crimes, or will the judge have to sentence Danny to serve back-to-back sentences?
This is in the judge's discretion. What we're calling 30 to life is actually 2 15 to lives. Each one of his convictions carries a minimum mandatory sentence of 15 to life. So we're assuming the judge is going to do a consecutive, what we call consecutive. In cases like this, that's fairly common because these are different victims and the crimes occurred in different time periods. It would be different if he was convicted of grand theft auto and using a firearm in the commission of a felony because he used the gun to steal the car. We'll stack those together because it sort of happened at the same time. And the GTA, whichever one's longer, is not going to matter necessarily. But in this case, I'm expecting the judge to go consecutive back to back and not consecutive concurrent.
Awesome. Guys, if you're one of the 2,800 people watching live, please do us a quick favor and hit that like button. It really does help out. Zach, this was awesome. I'm glad we were able to do a simultaneous stream to your channel. Let me remind everybody, you can go over and subscribe to Zach on YouTube at Your Lawyer Friend Zach. He's got some fantastic stuff. Thanks for joining me for this, man. I really appreciate it.
Glad, thanks for having me. Well, I know I've got some other things we want to discuss too in the future. So you've been waiting on me to have availability. It's not me waiting on you. It's you waiting on me. So we'll see if we can find some time to get it nailed down and do it again.
Thanks for joining us, everyone. Thanks to everyone who watches until the very end. We'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.